So if the judges want to do a really quick introduction about themselves.
Good morning, everyone. My name is Aya Fahmi. I'm a law student at Osgoode Hall Law School. I'm very happy to be here, and I wish everybody the best of luck.
Good morning, everyone. I'm Caitlyn Kasper. I'm a senior lawyer with Aboriginal Legal Services in Toronto. This is my 4th year judging at Lions Cup, and I'm very excited to be with everybody on the last day.
Hi, everyone. My name is Annie Hu, and I'm also a law student. I actually competed last year, so it's really interesting to sort of sit on the other side. But I'm really excited to see the teams today. Good luck.
I believe we are ready to start, and the first appellant speaker, whenever you're ready.
All right. May I proceed?
Yes, you may. Go ahead.
Good morning, Justices. Good morning, friends. My name is Rosalie Martin, and along with my co-counsel, Gracie Daze, we'll be representing the appellant, Her Majesty the Queen, in the case at bar. Before I proceed, I would like to take the time to acknowledge that as a resident of Waterloo Region, I'm submitting from the traditional lands of the Haudenosaunee, Anishinaabe, and Neutral peoples. And I understand that with this land acknowledgement comes the responsibility to decolonize the spaces that I occupy. The issue before the court today is whether or not Richard Lee Desautel can hold a Section 35 right if they are not a citizen nor resident of Canada, and it is a threshold question. Our submissions for the court today will be twofold. First, I will submit that a purposive interpretation of Section 35 indicates that it was not intended to apply to Indigenous peoples that are not citizens nor residents of Canada. Second, my co-counsel will submit on the negative policy consequences of widening the interpretation of Section 35. Would the court like a recitation of the facts?
No, thank you. Please proceed with your submissions.
Section 35 protections apply to Aboriginal peoples of Canada, and the lower court erred in relying on the Vanderpeet test to establish that the entire modern Indigenous community can potentially qualify as Aboriginal peoples of Canada, because this is a separate issue, as I have stated, and a threshold question. In order to determine that, then, the process requires a purposive analysis of the text to determine how it should be applied. And while the appellant is cognizant that sections should be interpreted in a generous manner, it still has to be done so consistent with that section's intended purpose, and the court cannot go beyond the bounds of what constitutional interpretation allows for, as stated in the case of Manitoba Métis Federation Incorporated and Canada Attorney General.
Counsel, but you would acknowledge, would you not, that in the development of Section 35 and the negotiations thereof, that there was no consideration of Indigenous peoples outside of Canada, correct?
That is correct, Justice.
Okay, so any interpretation that you're going to present to us today is based on what?
Justice, in terms of how to interpret this statutory provision, we have to look at the linguistic context, the philosophical context, and the historical context. And so starting with the linguistic context, in terms of determining the meaning of Section 35, it's important to look at the individual words that are chosen and used by the framers when creating this provision. As stated by R. Sullivan at paragraph 106 of the case, it is presumed that every feature of a legislative text has been deliberately chosen and has a particular role to play in the legislative design. So constitutional interpretation has to start with the language of the law that's in question, as called for in the case of British Columbia Attorney General and Canada. In this case, the words of importance are the use of the word "of" as a qualifier in the phrase Aboriginal peoples of Canada. The word of points to a place of dwelling and is meant to be seen as the person spoken to dwells in the place that they are named.
Okay, Counsel, but you would also agree that when we talk about dwelling, you would acknowledge that it's very clear that the antecedents of the Sinix tribe did dwell in Canada, and so therefore would qualify under the of, would they not?
The historical Sinix tribe members who dwelled in Canada would qualify as Aboriginal peoples of Canada. However, the descendants that do not live in Canada and do not dwell in Canada themselves, they do not qualify as Aboriginal peoples of Canada because they are not on the land.
But they would be successors of the individuals. And so therefore, would they not have inherited all of the rights that the Sinix tribe would have had?
No, Justice, since they are not citizens of Canada and they are not on the territory, then they cannot hold the constitutional right of Section 35.
Okay, but we're talking about two very different things here. You're talking about geographic locations and you're talking about citizenry. So break that down for me. What are you really concerned about here?
In the case at bar, the issue is whether or not someone that is not a citizen or resident. So regardless if they have citizenship, or sorry, if they don't have citizenship or residency and aren't located on Canada. So they have to have one or the other in order to qualify as an Aboriginal person in Canada and to have the rights that are affirmed in Section 35.
Okay, so I just want to make sure that I understand your argument. So this is based on the premise of both geographic location and citizenry. And you're saying they need to have either one or the other in order to qualify as
Yes.
being the successors of these rights.
Yes, and we would also further submit to you that this isn't meant to set a blanket requirement, but should then be interpreted on a case-by-case basis going forward in the future due to the unique fact-specific evidence that has to be looked at when determining whether or not a person holds an Aboriginal right and can qualify for an Aboriginal right.
Okay, but are you talking about the issue of continuity at this point?
That wasn't what I was submitting to today. However, we can discuss the issue of continuity because in this case, there is an 80-year break in the continuity in practice.
Okay, but what I'm saying to you is that you're saying that in the future, this is going to depend on a case-by-case basis. But based on what you're saying in terms of either citizenry or geographic location, that to me says that there is not going to be any case-by-case analysis moving forward. That this is very strict requirements. You have either one or the other. So the issue of continuity would never even need to be addressed. Is that your submission?
No, Justice. The issue of continuity is a part of the Vanderpeet test and the analysis that takes place in that case. So while continuity is discussed in the initial threshold question, it's separate in that it takes place in the Vanderpeet test, specifically in steps 2 and 3 of the Vanderpeet test.
Right, but if the person, what I'm saying to you is that you say that this is going to in the future be a case-by-case analysis for Aboriginal groups to qualify under of Canada. Is that correct, what you're saying?
No, Justice. The case-by-case analysis takes place after they meet the threshold question.
Counsel, so the threshold question is a matter of constitutional interpretation. Is that what you're saying? So you're saying the way we interpret the Constitution is we're going to know who are the Aboriginal people of Canada and who are not, and accordingly, we elect to either apply the Vanderpeet test or not?
Yes, Justice.
Okay, so going back to that constitutional interpretation and specifically to language, don't you think that your interpretation of Canada is too strict and narrow, which goes against the principles of constitutional interpretation? Let me explain that further to you, Counsel. You're saying that of Canada means in Canada, whereas in French, it's du Canada, which can also mean from Canada. So from Canada originally, would you not think that this is a more just and expansive interpretation of the language?
Yes, Justice, while it can be interpreted more loosely in the French language, the scope is not too narrow because it serves an explicit purpose. And the purpose of Section 35 and that purpose is reconciling and reconciliation between non-Indigenous and Indigenous peoples located in Canada. And so by broadening that scope, it would then make the words of Canada redundant and not serve a purpose. When interpreting and doing constitutional interpretation, as stated in the case of British Columbia and Imperial Tobacco Limited, you can't make the words become redundant. They have to still carry meaning. And so the words of Canada are there to serve.
But the constitutional drafters do not shy away from being explicit in their meaning. If they wanted to say Canadian citizens and permanent residents, they could have said that, or they could have said located geographically in Canada. So don't you think that of Canada, a word that carries multiple meanings, would make it open to multiple interpretations? You may have a brief indulgence to just answer the question and conclude.
Sorry, may you repeat your question for me? I just got distracted seeing
the question is that the drafters of the Constitution know how to be explicit. So they could have said Canadian citizens or Aboriginal people located geographically in Canada. So would the fact that they have not give rise to a more expansive interpretation than yours?
No, Justice. The framers were still explicit in their intentions of making Aboriginal peoples of Canada to mean those located in Canada, because their purpose of Section 35 is highlighting the purpose of reconciling Indigenous peoples and non-Indigenous peoples in Canada. And so because we know that that's what their purpose was, then we can interpret that to mean...
Your indulgence has elapsed. It's only 15 seconds.
Okay, thank you.
May I proceed, Justices?
Yes, go ahead.
Thank you. Good morning, Justices, and good morning to my friends. My name is Gracie Daze, and I will be completing the latter of the appellant submissions on behalf of the Crown today. I'd just like to take a moment before I start to acknowledge I am located in Ottawa, Ontario. I'm living and I'm working on the unceded traditional territory of the Algonquin Anishinaabek people. My submissions today will be singular in nature, pertaining to the public policy considerations on this matter. Justices, a ruling in favor of my friends today has foreseeable consequences for both the Crown and Indigenous communities residing in Canada. It is important for the court today to consider the slippery slope and the implications of allowing Aboriginal communities who are not Canadian citizens and who are not residents of Canada to exercise Section 35(1) constitutional rights. If an Aboriginal group from outside of Canada...
Okay, Counsel, I'm just going to interrupt you for a second because I think I need some more clarification on your co-counsel's argument. Are you also of the opinion that the threshold question is determinative of geographic location as well as citizenry?
Yes, Justice, the appellant submits a similar submission as my co-counsel stated. And I'll refer to the case of Big M Drug Mart in terms of constitutional interpretation, which states that in order to understand Section 35(1), we need to understand it in relation to the interests that it was meant to protect. Section 35 is meant to protect, according to the case of Mitchell, Aboriginal peoples as full participants with non-Aboriginal people in a shared Canadian sovereignty. This characterization has been demonstrated in other cases by this court. For example,
excuse me, Counsel, I just want to interject. So your statement about Section 35 protecting the interests of Indigenous people. And here we have a case that involves Indigenous people and denying them the benefit of Section 35 rights. So that to me indicates a very patriarchal and patronistic version of the courts and the government deeming that how they're going to protect the interests of Indigenous people of Canada as excluding those who do not reside or have citizenship here. Would you not agree with that?
No, Justice, respectfully, it's the position of the appellant that reconciliation and furthering our relationship with Indigenous communities is the priority here. The appellant submits that if an Aboriginal group from outside of Canada can exercise Section 35(1) rights, then they should be offered the same protections under our Constitution in full. They need to be able to access a full panoply of rights under our Constitution, and anything less than that standard, Justice, is not going to further the reconciliation process that we have ongoing with Aboriginal.
Okay, Counsel, so what you're saying is the argument that Section 35 rights are should be accessed in full by anybody afforded them, correct?
Yes, Justice.
Okay, and so you're saying that that would be impossible to do for individuals who are descendants of people of Canada, but who do not currently reside in this country.
Yes,
it would be impossible for us to offer the full protection of Section 35.
Well, Justice, impossible is a broad statement. By extending Section 35(1) rights to individuals who are not Canadian citizens, who are not residents of Canada, we're opening the floodgates for concerning consequences that are going to run counter to the reconciliation process we're seeking to achieve.
So what you're saying, Counsel, is that it's not impossible, it would just be difficult or hard for the government to do. And that's why they don't want to do it.
No, Justice, the position of the appellant is that should we offer these rights to individuals who reside outside of Canada, who are not citizens of Canada, who are not voting in our country, who are not contributing to our national diversity, who are not Canadian citizens, we run counter to the reconciliation process for those Aboriginal people who do reside in Canada. And I'll make reference to the duty to consult, for example, just to sort of further this argument. The duty to consult is an integral part of Indigenous reconciliation. It's a measure that's used to ensure there are no adverse effects on Aboriginal treaties or rights that could be at risk. If I'll refer to the case of Haudenosaunee Nation.
You know what, actually, I'm not interested. I think that given the case law, the idea of duty to consult is, it's not one that I want to hear further submissions on, given the history of duty to consult and the fact that it often very much does not protect Section 35 rights of Indigenous people. So I think I'd like you to move on to the next argument.
Sure, Justice, a moment of indulgence. Justices, Section 35 is meant to protect Aboriginal peoples as full participants with non-Aboriginal people in a shared Canadian sovereignty. This characterization has been demonstrated in the courts, for example, in the case of Beckman and Little Salmon Carmacks First Nation, which described the purpose of Section 35 as reconciliation of Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship. In addition to this assertion, the court's decision in that case emphasized the centrality of residency. The appellant submits that the decision to entrench Section 35 into the Constitution Act.
I'm just going to interrupt you, Counsel. When you say that it's centered on residency, can you tell me a little bit more about why that residency was important?
Yes, Justice. The decision to entrench Section 35 into the Constitution Act and the recognition and affirmation of existing Aboriginal treaty rights signaled a commitment by Canadian leaders to uphold the protection and to preserve constitutional space for Aboriginal people in Canada. But at the same time, these people do not by reason of their heritage, cease to be members of Canadian society who fully participate with other Canadians who may not be Aboriginal in their collective governance. Groups that reside outside of Canada, individuals who do not have Canadian citizenship, who are not Canadian residents, simply do not participate in Canadian society in the same way that Aboriginal groups here would. Therefore, justices, individuals who reside outside of our nation, who are not residents, cannot claim rights under Section 35. In doing this, we risk the careful process of accommodation, and we could be acting contrary to our reconciliation processes. Justices, the appellant submits that we are not turning a blind eye to the past. We acknowledge that colonial oppression has existed in Canada for a very long time, but rather the appellant submits we would like to further the reconciliation process and meet the national objectives of bringing justice to our Indigenous people. But this must be done with a meaningful interpretation of Section 35(1). Now, justices, you've heard submissions on behalf of the appellant from my co-counsel and I. And should you find our submissions to be compelling today, we ask that you uphold this appeal and dismiss the decision made at the Supreme Court of Canada. Barring further questions, the appellant rests.
Thank you.
Respondent, whenever you're ready.
My apologies, Justices, just getting set up. May I proceed?
Yes, you may.
Thank you. My name is Navia Shet, and I am here with my colleague, Leisha Shah, on behalf of the respondent, Mr. Richard Lee Desautel, in the case at bar. It is the respondent's position that the Supreme Court of Canada was correct in finding that Mr. Desautel is a member of the Aboriginal peoples of Canada who can claim a right to hunt under Section 35 of the Constitution Act of 1982. We posit that this court must err on the side of generosity in constitutional interpretation in order to acknowledge the unique harms done to Aboriginal peoples through systems of colonization and to promote the unique objective of reconciliation. To this end, the respondent has two submissions to make today. Our first submission, which I will address, is that a purposive interpretation of Section 35 extends protection to modern successors of Aboriginal peoples who were on the lands at the time of contact. Our second submission, which my colleague will address, is that there is sufficient evidence to support a finding that Mr. Desautel has a right to hunt under Section 35. In light of these two submissions, we respectfully request that the Supreme Court of Lions Cup dismiss this appeal, uphold the ruling of the lower court by exempting Mr. Desautel from the provisions of the Wildlife Act, and uphold his acquittal. To begin with the first submission, it is our position that the Supreme Court of Canada was correct in turning to past jurisprudence to determine the purpose of Section 35, as the court found in the 2020 case of Newfoundland and Labrador and Anishinaabe. Defining Section 35 rights is a task that has fallen largely to the courts. And in looking at this jurisprudence, it is clear that our friend's position that Aboriginal peoples of Canada under Section 35 must be currently located in Canada is inconsistent with its principles. It is our position, moreover, that there is not one grand purpose underlying Section 35, as was articulated in Beckman.
Counsel, I'm going to interrupt you. In terms of the threshold question that was raised previously, I want to know what your position is in terms of the requirement for both residency and citizenry in terms of ability of Indigenous people to access Section 35 rights.
Absolutely.
Yeah. Sorry. Oh, I was going to say, I want to know whether or not you believe there should be any threshold requirement at all prior to the Van der Peet test. And if you believe that there should be, what is it?
Justice, it is our position that it is a threshold question of who may be a member of the Aboriginal peoples of Canada, and it is determined by a relationship to the land, but not by a citizenship or residency requirement, rather by a successorship requirement, which takes into account the occupancy of the lands that became Canada at the time of contact and traces the modern successors of those peoples. Those peoples qualify as Aboriginal peoples of Canada. I would add that there would have to be a different criterion for the Métis, which is not before this court at this time, as the Métis have always had unique rights under both Section 35 and Aboriginal law in general as a result of their unique heritage.
So I just want to sum this up for you, and you can agree or disagree. So in terms of a threshold question, your submission is that it should not be based on citizenry or current residency, but rather whether or not these individuals are successors of a First Nations community at the time of contact.
And pre-contact justice. It is our position that it shouldn't be fixed in a particular time, but rather look to the historic occupation. And further, it is our position that such an interpretation is consistent with the jurisprudence, which looks back to the historic occupation and practice of Aboriginal peoples, and then articulates those as modern rights within the Canadian legal framework. And Aboriginal law does this both in the case of Aboriginal rights and in the case of Aboriginal title. And here I'd like to briefly address our friend's submission with respect to Beckman, because Beckman was a treaty case. And as the court found in the 1996 case of the Queen and Badger, Aboriginal and treaty rights differ in both origin and structure. And so it is our position that to look to the case of the treaties for the origin and structure of Aboriginal rights more generally would be a mistaken approach, as treaty rights originate in written agreements, whereas Aboriginal rights originate from historic occupancy and practice, as I explained. And so if we look to the tests for Aboriginal rights.
So let me just interrupt you for a minute, because you've mentioned that your interpretation extends to both rights and title. And aren't you concerned with the implication of that extension, particularly with regards to title? Because you are essentially calling for the court to set a precedent where a group that is residing outside of Canada can claim title to land in Canada, which is very, let's say, problematic in terms of sovereignty and territoriality.
So I'd like to address that question in two parts, Justice, if that's all right with you. Firstly, I'd like to address the question of whether it is our position that all Aboriginal peoples of Canada under our definition can claim title. And it is our position that they can and that they should, because it advances reconciliation to acknowledge their claims on the land. However, that does not mean that all Aboriginal peoples of Canada who are not located in Canada automatically have a right to title, because they must still undergo the Delgamuuk test and prove that they do have an ongoing relationship and occupancy of the land. And therefore, it is not, as our friends will suggest, a floodgate situation that will result in a number of title claims, as the number of people who may make claims as Aboriginal peoples of Canada is still inherently limited by those peoples who were on the land prior to and at the time of contact. And Justice, our friends have further submitted that in the cases of particularly Mitchell, the court has referred to Aboriginal peoples of Canada as being members of Canadian society. Here I'd like to pause and note that in both the cases of Mitchell and Vanderpeet, the cases before the courts had to do with Aboriginal peoples who were already located in Canada. And the court has never previously had to consider a situation in which Aboriginal peoples who are not located in Canada could claim rights under Section 35. And in creating this new interpretation, it is important not only to remember that the law must be interpreted in a manner that is generous to the rights of Aboriginal peoples, but that constitutional provisions in general must be capable of growth and development in order to meet the expectations of new realities that were unimagined by their framers, as the court found in Hunter and Southam. And in
Counsel, your position is that the ultimate aim of taking, say, a propositive approach to Section 35 is reconciliation and reinforcing rights of Aboriginal people in Canada. However, if this results in conflicting rights, do you think this would necessarily aid reconciliation if all of a sudden that Aboriginal people's rights as citizens of Canada are trumped by those that aren't citizens of Canada?
Respectfully, Justice, we understand your concern with respect to conflicting rights by groups who are located perhaps within Canada and without Canada, but the courts would have to perform balancing acts even in light of conflicting claims by groups within Canada, firstly, and beyond that, Justice, the level of claim for different groups that exist with different relationships to the land can also be determinative of which group has more of an access to that right, for example, and that the fact that there are two groups with claims to the same land should not bar the courts from allowing either of those groups the chance to have a claim to that land or to that right. And as the court found, sorry, my apologies, in Powley, difficulty in administering rights is not an excuse to prevent those rights from being available to those who claim them. I'd like to briefly address our friend's concern about the linguistic context of the provision before I conclude. They've suggested that to interpret Aboriginal peoples of Canada in the manner that we've suggested would be to render the words of Canada redundant. We disagree.
You've spoken about a constitutional interpretation where the living tree principle, where it's capable of growth and expansion. However, it is not absolute and limitless growth and expansion, right? Where would you place the limit in that context? Because your friends have submitted evidence of drafters' intent to limit Aboriginal peoples within Canada. So what would be your response to that?
I see my time has nearly elapsed. If I may briefly answer your question and conclude.
Yeah, quickly wrap up.
Thank you. Yes, Justice, we understand that there is a concern with respect to drafters' intent, but there is no evidence to show that the drafters ever contemplated this issue, and in line with the general purpose, which still places a geographic limitation but does not freeze it in the modern day, it is appropriate to read the provision in this manner, and it does not exceed either the linguistic, philosophic, or historic context of the provision. Barring any further questions, that concludes the first submission on behalf of the respondent. My colleague will now address the second submission. Thank you.
Thank you, Counsel.
May I proceed?
Yes, you may.
Good morning, Justices. My name is Laisha Shah, and I will be concluding the final submission on behalf of the respondent, Mr. Richard Lee Desautel, in the case at bar. I will be addressing the public policy concern raised by our friends, as well as the dissent, and while our friends have failed to address the question of whether Mr. Desautel has a protected Aboriginal right to hunt, as it is our position that Mr. Desautel and the Lakes Tribe are Aboriginal peoples of Canada, proceed with a test for an Aboriginal right, as set out in Vanderpeet. And while Justice Kasper has rightfully addressed our friend's concern of the duty to consult, for the sake of completeness, I would like to address our friend's concern as well as its dissents. Aboriginal groups outside of Canada are not implicated in the consultation process to the same degree. The duty to consult still comes from the honor of the Crown, so it still mandates that we enact this consultation. And while the consultation process may be more challenging when it involves groups outside of Canada, as the Supreme Court of Canada has established in the case of Powley, this does not excuse the Crown from consulting with groups for the reason that it is difficult. Further, Aboriginal communities are not uniform. Each community has different circumstances, and so we're all implicated to a different level. So this is something we already deal with as it's presently situated. Now, to address the Vanderpeet test itself, it is our position that the majority was correct in their application of the Vanderpeet analysis, and the evidence is sufficient to meet the test. The test comes from the 1996 Supreme Court of Canada decision of the Crown in Vanderpeet. There are 3 stages to this test. The first stage is to characterize a right claimed in light of the pleadings and evidence. The second stage.
It's not you don't have to repeat the Vanderpeet test. We're very well aware of it. I have a question in terms of the threshold question. So your indication is that also that there is no requirement for residency or citizenry, and duty to consult should not stand in the way of being able to provide Section 35 rights, correct?
Yes, Justice. That is
okay. Okay, and so my question is, when you have established First Nations in the area of that have been living in Canada while the Sinix tribe has not been there, there may be issues that come up in terms of allowing another group who has not been in that area for generations to come forward and all of a sudden access rights for space that may or may not be occupied by other First Nations who also have rights and title and claims to that area. So how would you justify those types of competing interests for Aboriginal people under Section 35?
I understand your concern, Justice. However, I'd like to answer your question in two parts. First, we would like to address that the Sinaics were moved involuntarily, and while it was a constellation of factors, ultimately it was an involuntary move to what is now Washington. And further, indeed, there have been tensions between the settlers and the Lakes tribe, as the trial judge found at paragraph 99 in the trial judgment. However, this was not tension that was between the Lakes tribe and the Canadian Indigenous groups that were not displaced by the forces of colonialism. And so we must keep this in mind when establishing the second and third stage of the Vanderpeet test. And as such, the dissent did not find that the hunting in Washington was sufficient. However, keeping in mind the barriers that Indigenous peoples who have been displaced from their primary territories face, this is not simply in the minds.
Are you of the position, Counsel, that any type of consultation or speaking with other Indigenous groups in the area should occur prior to giving a non-resident Indigenous successor group rights? Should there be consultation with the First Nations that are currently in the area?
Absolutely, Justice. And that would indicate that there is a different degree that Indigenous groups residing outside of Canada would be implicated too. And citing the case that our friends have suggested to the court of Haudenosaunee in British Columbia, that the Crown will approach the Indigenous peoples who are more affected by the concern that they are consulting about before groups that are less implicated. And so, yes, we would agree with that statement, Justice.
Okay, and so this would be under the process of duty to consult, is that what you're saying?
Absolutely, yes.
Okay, and then the best forum for that type of consultation should occur how?
Through constitutional conferences established in the case at bar, Justice.
Okay.
The majority does not find that hunting in Washington is sufficient. However, the lower courts rejected this submission, holding that the Vanderpeet test has never included such a requirement, and to do so would ignore the Aboriginal perspective, the realities of colonization, and do little towards achieving the ultimate goal of reconciliation. As such, we urge this honorable court to read the Vanderpeet test generously, keeping in mind the grand purpose of reconciliation, which grounds Section 35 when applying this test.
Counsel, I understand that you're referring to the unbroken chain of continuity or the continuous practice all along not being a requirement of the test. And I don't think this is being contested here, but one of the points of contention is about how integral the practice is. And for a practice that is so integral, how would you justify it being discontinued for 80 years? How much of an effect do you think that would have on our interpretation of the test?
I would like to answer your question in two parts. First, Vanderpeet does not include such a requirement of a site-specific requirement for continuity as well as integrality. However, if we turn to the trial judge's reasonings at paragraph 101, it states that the Sinaics people felt unwelcome in what is now BC. And there are instances where there was gun violence and tensions between the Lakes tribe and the settlers. And so we must take into account the Aboriginal perspective, which this court has underlined as important in the determination of Section 35 rights. The interpretation that we propose to this court appropriately respects the many ways that ancestral ties to land may remain for people involuntarily displaced by the forces of colonialism. and provides appropriate flexibility in light of the significant challenges faced by contemporary Indigenous peoples seeking recognition of their Aboriginal rights. These challenges include the amassing of historical evidence across long time periods, the reality of intertwining genealogical connections with neighboring communities, and the divisions and dispersal that many Indigenous peoples experience as a result of colonial forces, such as the imposition of boundaries, reserve creation, and residential schools. The outcome would be—
Counsel, what is your position on the fact that we are going to be granting Section 35 rights and undergo a process of reconciliation with non-resident Aboriginal people, given the fact that in their history, if you take a look at it, 18 was before residential schools were even at their height. It was before a lot of the real intergenerational traumas that precipitated the Truth and Reconciliation Commission and this idea of reconciliation. We are essentially granting Section 35 rights to and undergoing reconciliation with a successor tribe that didn't even experience the same Canadian histories. Tell me, what are your thoughts on that?
Justice, I would like to answer your question in 3 parts. First, we posit that reconciliation is between Aboriginal and non-Aboriginal peoples of Canada. And as it is our position that Mr. Desautel, as well as the Lakes Tribe, are Aboriginal peoples of Canada, they would be included. And further, as my colleague has outlined for the court, what is necessary to prove an Aboriginal peoples of Canada is that prior to contact, they resided on that land, which is now within what is now Canada. And further, in reference to the historical injustices, I was referring to the continuity and integrality element. The Supreme Court of Canada, in the dissent, said that this was merely in the minds and is not cognizable. However, this is the Aboriginal perspective we must take into account. And this is not merely intangible. It is tangible and identifiable. There are significant barriers that these peoples faced that precluded them from the right to hunt. I see my time has elapsed. May I briefly conclude?
Yes.
Thank you. Justices, this is an opportunity for the movement of reconciliation for the Sinixt and for the country and Mr. Desautel himself that paves this pathway once and for all. We implore this court to finally fulfill the promise of reconciliation, to dismiss this appeal and uphold Mr. Desautel's acquittal. Barring any further questions, this concludes the final submission on behalf of the respondent.
Thank you.
Thank you.